This is part 3 of a 4-part video series dedicated to walking you through the domestic violence process. Emergency protective orders will always contain certain provisions. All orders are effective statewide. All orders tell the respondents not to abuse, harass, stalk, threaten, intimidate, or cause fear of bodily injury to anyone named in the petition. Orders also tell those accused of committing domestic violence that they must not carry or possess a firearm or ammunition while the order is in effect, even if they have a valid license. Respondents also cannot have any weapons in the place they live or anywhere on the property where they live. Emergency protective orders can also include other stipulations. Orders can determine who can live in or be near the family home, and whether the respondent can go near a workplace or a school. Orders can keep respondents from contacting certain people. Orders can set rules for financial support of and visitation with children. Orders can grant someone temporary custody of children. Orders can force someone to attend a treatment program. Orders can also deal with personal property. In short, orders can include anything that is necessary to protect the physical safety of people the magistrate believes need to be protected. After signing an emergency protective order, the magistrates will send copies of the order electronically to law enforcement agencies. Emergency protective orders are only temporary. In each case, a magistrate issuing an emergency order will schedule a hearing in family court. The magistrate's order will last only until that hearing. The hearing in family court gives people accused of domestic violence a right to respond to the accusations and to tell their side of the story. Respondents have a right to know what they're being accused of doing. They have a right to know when a final hearing is scheduled in family court so they can attend. Because it is so important that respondents know these things, police officers hand-deliver copies of emergency protective orders to them within 72 hours of the time the orders are issued. This is called serving the order. When they serve protective orders, law enforcement officers tell respondents that they must surrender any firearms to the officers or to any other person who is legally allowed to have them. This is why it is so important for people who file domestic violence petitions to tell the magistrate in the petition whether the accused person has any weapons. If a respondent has not received notice of the family court hearing by the date it is scheduled, the hearing can be extended. The emergency protective order will remain in effect until the hearing. Officers who serve protective orders should explain to respondents what the orders mean and what they can and cannot do. Protective orders are issued to keep adults and children safe. It is important that people who are accused in protective orders not have contact with anyone the orders protect, even if the other side initiates contact. If an order is violated, the protected person should contact law enforcement immediately. Next, we will learn about family court, preparation for family court, and the final orders. These will be discussed in Part 4.